When a court relies on a guardian ad litem or custody evaluator, it is not actually hearing the child's voice. It is hearing the child's experience filtered through someone else's interpretive framework. And that layer of interpretation, though often described as protective, may be one of the most dangerous features of the modern custody system. The goal of hearing from a child should not be to ask emotionally loaded questions, like which parent the child prefers or loves more, but to obtain simple, factual information about the child's lived experience, such as what a normal morning looks like at each home, who usually takes the child to activities, or who helps with homework when there is a problem. These are objective facts directly relevant to stability, caregiving, and routine, and asking them is far less intrusive than the emotionally charged, theory-driven interviews often conducted by professionals tasked with diagnosing family dysfunction and forming custody recommendations. Judges are capable of assessing the credibility and demeanor of a child, answering factual questions, but it is far more difficult for a judge to evaluate the credibility of a professional who, without any objectively verifiable record to review, claims the child said one thing but meant another, or who reframes the child's statements through psychological theory. Prioritizing direct, factual testimony with appropriate safeguards such as limited scope, non-leading questions, and testimony outside the formal courtroom when necessary does not force a child to choose sides. It simply asks the child to be a witness to his or her own life. That approach values direct evidence over subjective interpretation, reduces distortion, preserves accountability, and respects both the child and the court's fact-finding role. Filtering a child's experience through layers of adult interpretation does not reduce harm. It obscures the record, and the safest evidence is often the simplest evidence when it is handled with care and restraint.